this question is probably not relative to any of you right at the moment, but if you move to a higher court in the North Carolina system, these are the things that we would like to know. This question is very simple, okay, and it's got two parts, and I'm going to ask you to give me the answer to the first part. What are the 4 most important words in the Second Amendment?
I have no clue. The 4 most important words in the Second Amendment: right to bear arms.
Right to bear arms, and you shall not be regulated by the government.
Shall not be abridged.
I'm going to go with Roy's answer on that one.
That's a very smart choice, because the 4 most important words in the Second Amendment are shall, I'm sorry.
Shall not be abridged.
No, it shall not be infringed. Okay. Now, if you people understand what the word shall not be infringed means, okay, that means that we should not be having gun laws that are passed by the states that infringe our right to bear arms. So which of you tonight will swear to interpret the law as it is written in the Constitution? Case law is like the game of telephone. You know, when you start with a secret at one end and you pass it around from person to person, and by the time it gets to the other end, you can't even recognize it. So which of you are going to swear to us tonight that your sole and primary source for every decision you make will be the Constitution of the United States and nothing else?
I can't say that it would be the sole basis of a decision, but the oath we take is to support and defend the Constitution of the United States of America and the state of North Carolina. There are limits and laws that follow that are things that are not dictated by the Constitution.
I'm only talking about things that are dealt with in the Constitution. If there's a conflict between the Constitution and...
Well, as I said, almost 14 months ago, I took the oath of office. I swore to uphold the United States Constitution, the Constitution of the state of North Carolina, and the laws of the state of North Carolina, which I do every day and will continue to do. We do not change law on the district court level. The Court of Appeals and the North Carolina Supreme Court and the United States Supreme Court, they follow what is called stare decisis. And I think what you're wanting to know is, if I were ever elevated to a position such as that, would I follow the Constitution or would I follow the doctrine of stare decisis? And I think the answer is both. And I think what you see is when the judges do that in a true and accurate way, you get good decisions, like the decision that just came from the United States Supreme Court that puts a limit on the states infringing upon the citizens' rights to bear arms. If you're familiar with that case, it just came out. It was a 5-4 vote. You should read the dissent. The dissent really tried to interpret the Constitution in a way that I think is different from the way that it was written. It's clear in the Second Amendment that we have a right to bear arms, we have the right to form militias, we have the right to do things to protect ourselves against a government that is tyrannical. And while we're not facing the same exact issues today that we were in 1776, we have to try our best to interpret it in the light that it was written. Thank you.
Just this week I've been looking at a case. A friend of mine tried a case in the district court 2 weeks ago before another judge. It involved a man who had previously been convicted of a felony. And the laws of North Carolina, that, as it was amended about 6 years ago, said no one who's been convicted of any felony has the right to have their gun rights restored. And there's been reinterpretations of that. The courts have left it that it has to be, at this point, it has to be decided on an individual basis. So if someone wants to try to get their gun rights restored, they've got to go to the step of filing a lawsuit and taking it to court and having it interpreted. If I'm elected a judge, I will follow the law as it's been given in that kind of case. They set out some real specific things you're to consider when you weigh and make that decision. Some people would have their rights restored, some people would not. I would be bound to follow the law. Certainly, each of these cases discusses the original intent of the Second Amendment, and that ought to be the core. But as judges, we're not to make new law. We're to apply it as it's been decided by higher courts. I would say I'm not intended to run for the Court of Appeals or Supreme Court.
Thank you. Mr. Weejay Wickrell.
As a district court judge, I said this earlier, I have no choice but to follow the law, and that starts with the Constitution of the United States. You know, well, I can't tell you how I rule on a case, but I can tell you that my authority comes from the Constitution of the United States. The Second Amendment is a part of the Constitution of the United States in its entirety, and that would be the ultimate source.
Ms. Earwood.
Mr. Reed-Dickram is right. At this time, a district court judge has to follow the law. And the law of North Carolina right now, until somebody has enough money to fight this, is that if you are a felon, you can never have your rights restored. You can never possess a firearm again. We've had cases in every county, including Murphy, where we've had old farmers, we've had that have rifles on their property now that were convicted of a felony 25 years ago, 30 years ago. You're talking about, you know, when I say a felony, I'm not saying he went out and murdered somebody. I'm saying that he might have had a couple ounces of pot on him when he was 17, 18, 19 years old. And now, 35 years later, he might have had his rights restored. And the law of North Carolina is retroactive that says you can't have a weapon. I am trying a case Monday morning from a Superior Court judge possessing of a firearm by a felon. They're saying that the state's theory is that if you're a convicted felon, you can't even give your guns to your mama to keep them for your son because that's possession. So I can't tell you how to rule one case. What I think right now is that going retroactively for you know, older men and people that have never had a bit of trouble in their life again, and saying, I don't care if you had your rights restored, but you got to get rid of your rifle, you got to get rid of your weapon, your handgun, whatever it is. We are fighting these things in Superior Court. Unfortunately, nobody's had enough money to hire an appellate attorney at this point. You take it up to the Court of Appeals, take it up to the Supreme Court, and get an answer about whether this law is constitutional or not. But we are very affected by the Second Amendment, especially because we have a huge hunting community and huge group of folks that want to have handguns and want to have rifles. And right now, you are very limited to that. So I would follow the law right now as it is, but I think that there are a lot of issues that the Court of Appeals judges, the Supreme Court are getting ready to hear about that.
Thank you. Mr. Sutton.
I appreciate your concern with the question. I believe your intent is, what would we do in the event we're on the Court of Appeals or the Supreme Court? With all due respect, I don't think any of us ethically can say how we would do at that time. I can tell you this, that if I was ever to entertain that, my wife would probably leave me because we would have to relocate to Raleigh, and that's not something I'm willing to entertain. Because we just got married in September, and I'm happy. But as everybody else has already said, we're obliged to follow the law and the Constitution of the United States as it is written. In district court, there is no room for interpretation as a district court judge. So to that end, I can promise you that I will follow the law and the Constitution. I appreciate your question.
The point is simple. Taking the Constitution out and waving it around doesn't mean anything if you don't follow it.
Thank you. Please pass the microphone down.